Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Today, we're going to take a look at a courtroom appearance that immediately starts raising red flags. Before anything else can happen, the judge carefully explains the serious charge facing the defendant and warns him about the risks of representing himself. But instead of showing the level of focus you would expect in a case carrying potentially severe consequences, the defendant is casually chewing gum and already giving off the impression that he does not fully appreciate the situation he is in. Within moments, the tone of the hearing becomes clear. The judge remains professional and patient, but there is already a growing sense that this defendant may be heading down a very dangerous path by trying to handle such a serious matter on his own.
Thank you.
So I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a prelim.
You wish to have a preliminary examination?
Preliminary examination, yes.
Would the people have their witnesses available the second?
We can try your...
Today, we're going to watch the hearing move into the legal issues, and this is where things begin to unravel for the defendant. As he attempts to discuss discovery and request further proceedings, his arguments become increasingly difficult to follow. Meanwhile, the prosecutor responds with specific concerns regarding previous filings and allegations already addressed by higher courts. What makes this exchange so important is the contrast between preparation and confusion. The court is looking for clear legal reasoning, yet the defendant struggles to articulate exactly what information he believes is missing. Eventually, the judge openly expresses frustration and points out that the defendant's explanation simply does not make sense. At that moment, it becomes painfully obvious why legal representation is often critical in cases involving complex legal procedures and serious criminal allegations.
Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals in the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern of the court. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping to sort of reconcile both of those things as whether or not...
Today, we're going to step back from the courtroom itself and examine the behavior that brought us to this point. As the hearing concludes, attention shifts toward the defendant's attitude and overall approach to the case. Rather than appearing concerned about the consequences he faces, He seems determined to challenge the process, while offering very little substance to support his position. This is often where self-represented defendants run into trouble. Confidence can quickly become overconfidence, and questioning authority without understanding the rules rarely produces positive results. The more this hearing unfolds, the more it feels like the defendant believes he is controlling the situation, while in reality, he may be creating additional obstacles for himself with every interaction.
Discovery is something the defendant shares with the court, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response.
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my, what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the 2nd.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
Today, we're going to wrap up this hearing by looking at the bigger picture surrounding the defendant and the serious concerns being discussed. The commentary highlights issues extending beyond this single court appearance, including personal consequences that may have already affected important areas of his life. Rather than showing accountability or a strategy for moving forward, the defendant continues to project an attitude that leaves many observers questioning whether he understands the gravity of his circumstances. With another hearing scheduled in the future, this case appears far from over, and there will likely be even more significant developments ahead. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and turn on notifications so you do not miss future updates. Thanks for watching, and we will see you in the next video.